Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section hashtag VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual class and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer is an authority in criminal law and special penal laws. He has obtained his Juris Doctor and Master of Laws degrees from San Sebastian College Recoletos, Manila. He teaches criminal law and special penal laws at San Sebastian College Recoletos, Adamson University, New Era University, and Thomas Claudio Memorial College. He is a seasoned bar reviewer and MCLE lecturer. He has authored books entitled Criminal Law Concepts and Jurisprudence, Book 1 and Book 2 of the Revised Penal Code, 2020 edition, Special Penal Laws Concepts and Jurisprudence, 2019 edition, Concepts and Jurisprudence on Comprehensive Dangerous Drugs Act of 2002, 2020 edition, and Compendium of Special Penal Laws, 2019 edition, all published by the Central Book Supply Incorporated. Currently, he serves as an assistant city prosecutor in Antipolo City. Let us all welcome Professor Freddie M. Noyara.
Good day, everyone. I am Professor Freddie M. Noyara, and welcome to this free online lecture. Okay, brought to you by Virtual Law Companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity. Like the VLC Facebook page or subscribe to VLC YouTube channel and share this live session. Host or watch party and tag your friends now, and together learn at the comfort of your homes. Before we start, please comment VLC if you can hear me clearly. Now we will proceed to the lecture proper. My lecture here is entitled Critical Areas in Criminal Law. The study of criminal law, especially criminal law one, entails a lot of patience because this particular subject prepares you to a higher criminal law subject, which is criminal law 2 and special penal laws. And when you come to fourth year, you will study criminal law review. So since my lecture is limited only to 1 hour, I will just prepare one particular topic of criminal law 1, which to my mind is sometimes it is not given special attention by professors teaching criminal law 1, and that is extinction of criminal liability. This is a very important subject matter in criminal law 1, since many bar questions are sourced from this particular subject. In fact, last bar examination in 2019, there were 2 or 3 bar questions regarding extinction of criminal liability. So it is found in articles 89, 90, 91 of the revised penal code. Okay, the outline of the lecture will be, we will identify those modes of extinguishing criminal liability. And they are subdivided into 2. The first is partial extinction, and the second is the total extinction. We will identify those particular laws that govern this extinction of criminal liability, and we will discuss the important concepts and jurisprudence. Okay, the modes of extinguishing criminal liability. Total. Number 1 is death. 2, service of sentence. 3, amnesty and pardon. 4, prescription of crime. 5, prescription of penalty. Number 6, marriage and pardon. And so far as partial extinction is concerned, we have conditional pardon, commutation of sentence, good conduct time allowance, special time allowance for loyalty, and it is these next two modes are not enumerated, are not included in the enumeration, but for purposes of our discussion, we will include these 2 because the effect of parole and probation have also the same result, just like any other modes under the partial extinction of criminal liability. Okay, so we'll now start with what are the sources of these modes. We have to identify what is the source of this mode. For example, death or service of sentence. It is the convict himself or the accused who can terminate this when he dies or when he serves his sentence. Number 2, what about amnesty, pardon, commutation? Who grants this? It is the president, insofar as amnesty and commutation. Pardon and commutation. But if it is amnesty, it is granted by the president and with the concurrence of the Congress, pursuant to the Constitution. What about prescription of crime and penalty? who grants this? It is granted by operation of law. That is Revised Penal Code and Act 3326. What about GCTA or STAL? Who grants this? That is the Bureau of Correction, the Bureau of Jail Management and Penology, and the provincial wardens. Okay. What about marriage and pardon? Who grants this? Of course, the victim or the private complainant. And parole. Who grants parole? That is the Board of Pardon and Parole, pursuant to Act 4103. And pardon, the trial courts. I'm sorry, that is probation. That's not pardon. Probation. Trial courts, pursuant to probation law under PD 968. Okay. We'll now go to the lecture proper. Death. Last bar examination in 2019 bar exam, there was one bar question from on this subject matter. Okay. Death extinguishes criminal liability because if the accused dies, who will serve the sentence? It is useless to continue with the trial since nobody will stand to who will attend the trial if the accused is already dead. So the purpose of criminal case is to impose criminal liability on the accused in case he is found guilty. But if he dies, nobody will serve the sentence anymore. So death of the accused extinguishes his criminal liability. Assuming the death of the accused happens when the case is already with the appellate court. Meaning, the accused was previously sentenced by the trial court and he appealed the same to the appellate court. For example, Court of Appeals. And during the pendency of the appeal, he dies. What will happen to the case? The case will be dismissed because death of the accused extinguishes the criminal liability. But the problem here is, what about civil liability? Is it also extinguished upon the death of the accused? That is the problem. That is the bar problem usually given in the bar examination. Now you have to determine whether the civil liability survives the death. Under the civil code or the rules on civil procedure, you will know there whether the death of the accused survives the civil liability, or the civil liability survives the death of the accused. Now, if it survives, the civil liability survives, then the aggrieved party or the private complainant can run after the state of the deceased or of the accused. So, okay, he can file a claim running after the state of the accused. So, can file a claim against the executor or administrator. Okay, so if the civil liability survives the death, you can run after the state. So it does not necessarily follow that the civil liability is also extinguished upon the death of the accused. So you have to determine, that's a problem. You have to determine whether the civil liability survives the death. Okay, so that's clear. What about the issue on prescription on the civil liability or civil action? What happened if the trial court took 5 years to decide the case, and on the 5th year, the trial court sentences the accused guilty, and the accused filed a notice of appeal, and the case is now in appellate court. And during the pendency of the appeal, the accused dies. Assuming the civil action, civil liability survives, can the administrator or executor bring up the issue of prescription, saying that your action, your right to file civil action has already prescribed? Can it be done? Well, the answer is no, because the running of prescription, and so far as the civil action is concerned, is stalled, meaning during the pendency of the criminal case, there is no running of the prescription period insofar as the civil case is concerned. So when the accused dies during the pendency of his appeal, and assuming the civil action, the civil liability survives the death, don't worry about prescription, because the prescription, the running of prescriptive period is stalled upon the filing of the criminal action. Okay, so that's death. What about service of sentence? Easy. The service of sentence is being undertaken by the accused himself or the convicted felon. And how is it done? It is done by serving the sentence inside the national penitentiary. You will spend your time there. If you have been sentenced to imprisonment for 10 years, then you will spend for your time for 10 years inside the prison facilities of the national penitentiary. So service of sentence cannot be done outside. So it must be, you have to be detained there. Okay, you have to be in prison. So that's the way how to serve your sentence. Okay. What about, this has been a controversial issue, whether novation or compromise is a mode of extinguishing criminal liability. You know, novation under civil law takes place when there is some change in the relationship, contractual relationship between the creditor and debtor. Okay, so the subject matter is novated. There is a change in the contractual relationship. Now, applying the same in criminal law, is novation a form of extinguishing criminal liability? The answer is no. Why? Because novation is not one of those grounds for extinguishing criminal liability under Article 89, Article 90, 91 of the Revised Penal Code. You cannot find any provision that tells you novation is one of those. But novation, if there is a valid novation, will prevent the rise of criminal liability. If novation takes place before the institution of the criminal complaint, even with the fiscal's office or with the court, then it will prevent the rise of criminal liability. Okay, but that is not a mode of extinction of criminal liability. Okay, so I want you to give your attention to these three cases decided by the Supreme Court on novation. It will help you in resolving bar questions on novation. Okay, the first is the case of People versus Neri, or the so-called Neri Doctrine, decided by the Supreme Court in 1964, where the Supreme Court explained how novation can be applied with respect to criminal liability. The case of Neri is about staffa. Here, the private complainant entrusted the accused with 2 diamond rings to be sold on commission. When the agent failed to remit the proceeds, the complainant filed a case for staffa. And during the pendency of the case, the accused executed a promissory note in favor of the complainant. After tendering an initial payment, the agent or the accused failed to settle the entire obligation. So the private complainant filed a case against him. Now, the accused interposed novation since he there was he issued a promissory note. There was innovation according to him. What did the Supreme Court rule on the matter? The court observed that although novation is not one of the means that is recognized by the revised penal code to extinguish criminal liability, it may prevent the rise of criminal liability, or it will cast doubt on the true nature of the original basic transaction. Provided, however, that the novation should take place before the filing of the information with the trial court. So that is the condition there. So you have to observe that so that novation can be properly appreciated. It must be made before the filing of the information with the trial court. So if the novation takes place after the filing of the information with the trial court, then it has no validity at all. It cannot be given a valid effect. So take note of that. Take note of that. That is usually the bar questions. Okay. Now, in 1968, the Supreme Court rendered a decision in the case of People versus Tanhutko. Okay, and for purposes of our discussion, we'll just use Tanhutko doctrine. What is this Tanhutko doctrine? The accused here was charged with qualified theft. He invoked People versus Neri to support his claim that the complainant's acceptance of partial payment of the stolen funds before the filing of the information with the trial court converted his liability into a civil one, thus rendering baseless his prosecution for criminal case. Is he correct? The Supreme Court said, no, you are not correct, Mr. Tanhutko. Because unlike in Neri case, you are being charged here with qualified theft. And you have no prior contractual relationship with the private complainant. Unlike in Neri, there was a contract of agency under the civil law. Here, you are charged with qualified theft. It is impossible that you and the private complainant had prior contractual relations. Okay, which can be modified or altered by the parties. In the case of Neri, which is a case for Stapa, there was contractual relationship between the parties that can be the subject of a valid novation. Okay, so that's Tanhutko. Now, the last case is the People versus Milia, or the Milia doctrine, decided by the Supreme Court in 2012, where novation was also the subject of, is one of the issues of this case. What is this case all about? Milia was charged with estafa with falsification of public document. After he falsified a deed of sale and a transfer certificate of title. But before he was charged, he issued 2 checks to cover payments made by the offended party. Unfortunately, the checks bounced due to insufficiency of funds. He was convicted with estafa with falsification of public document. On appeal, he interposed the defense of novation. What did the Supreme Court say about his defense? Are you entitled to acquittal? The Supreme Court said no. the acceptance by the offended party of the checks could not have novated the original transactions, as the checks were only intended to secure the return of the 2 million pesos that was previously given to him. Even then, these checks bounced and were thus unable to satisfy his liability. And more importantly, this case involved estafa. Not only estafa, but it also involved falsification of public document, the civil liability of which cannot be extinguished by mere novation, because this is a complex crime of estafa with falsification of public document. Falsification cannot be novated. So, even in any case, estafa can be novated, but here it cannot, since it is a complex crime where a falsification of public document cannot be novated. Okay, so we will proceed. What about pardon and amnesty? Take note that there are two kinds of pardon. First, the pardon granted by the president and the pardon granted by the private complainant in cases or in crimes against chastity and rape. But here, the pardon here does not apply to the pardon crimes against chastity. We will discuss the pardon insofar as other crimes are concerned, not crimes against chastity, and the pardon granted by the president under the Constitution. What is amnesty? Well, amnesty usually is given or granted to political offenders. Usually, political offenders. It is an act of sovereign power, granting oblivion or a general pardon for a past offense, and is usually exerted in behalf of certain classes or persons who are subject to trial but have not yet been convicted. From this definition, you will know that the effect of amnesty is it erases all vestiges of the crime. The phrase granting oblivion means that whenever there is amnesty, all effects of a crime are obliterated or are erased or deleted. So the grantee of amnesty is a clean person, so to speak. Unlike pardon, the pardon does not erase the fact that the offender is an ex-convict. Okay? Amnesty erases all effects of the crime. And from this definition also, it is obvious that amnesty can be granted even if the offender is still being tried for the crime. Unlike pardon, pardon can only be granted when the conviction or the sentence has become final. So it cannot be granted when the case is still pending trial. In amnesty, it can be granted anytime. Okay, so that's the basic concept of amnesty. Amnesty is a public act which the court can take judicial notice. What does it mean? Amnesty is not valid even if extended by the president or granted by the president if there is no concurrence of the Congress. The Congress will pass a resolution concurring the amnesty. So it is a public act. Everybody is supposed to know it. That is not a private act of the president. Okay? So when the president extends amnesty and duly concurred in by the Congress, the court, or everyone for that matter, is supposed to know it because that is a public act. And the effect is you you you, you need not allege it. You need not prove it in court because the court can take judicial notice of the amnesty. Okay? And amnesty presupposes the commission of a crime. What does it mean? The accused must confess before he can be given amnesty that he is guilty to the crime. If he disputes or refutes the charges, then he is not entitled to amnesty because amnesty presupposes the commission of the crime. Okay, you don't have to say, oh, I'll accept the amnesty, but I just want to put it on record that I am not guilty. You cannot do that. You have to confess. You have to acknowledge your guilt before you can be granted amnesty. Okay. Civil liability is not extinguished by amnesty. Civil liability is not included. Okay. What about pardon? Pardon is under the so-called executive clemency power, the pardoning power of the president under the Constitution. A pardon is an executive prerogative of the president. Nobody can question it. If the president grants pardon to any person who is convicted, he cannot. Nobody can question that. It's like the case of Corporal Pemberton, the famous Corporal Pemberton, who was found guilty for the death of Jennifer Laude in Olongapo City. The president granted him pardon, even if the public was against that pardon. Nobody can question that before the court, even to the Supreme Court, because that is an executive prerogative of the president. Pardon is an act of grace proceeding from the power entrusted with the execution of the laws, and that is the president, that exempts the individual from the punishment which the law inflicts for a crime he has committed. That is the definition of a pardon. Pardon is classified in as absolute pardon and conditional pardon. An absolute pardon need not be received or accepted by the grantee. Okay, an absolute pardon is one which is extended without any string attached, without any condition. The pardonee has no option except to accept it, whether he likes it or not. That is absolute pardon. On the other hand, conditional pardon is one under which the convict is required to comply with certain terms and conditions. Since it is conditional, the pardonee has the right to reject it. Maybe for the reason that the conditions of it are more cumbersome, so he can reject it. So he must accept it. If there is no acceptance, there is no valid conditional pardon. Okay? So that's the distinction between the two, absolute pardon and conditional pardon. And a pardon looks to the future as contradistinguished from amnesty. It is not retrospective. It operates forward. So it does not operate backward. So the fact that you are a convicted person, that remains. It is not obliterated, unlike amnesty. So pardon looks to the future, looks forward. Question: can pardon restore political rights? as one of the accessory penalties. Can it restore political rights? That is the right to vote and the right to run for public office. The answer to that is yes. In the case of Joseph Estrada, when Joseph Estrada was granted pardon by the President Macapagal Arroyo, Estrada ran for mayor in Manila, and his qualification, his candidacy was challenged on the ground that he was a convicted person. So his right to run for public office was not restored. The Supreme Court said the absolute pardon granted to President Estrada restored his political rights. Okay, so it expressly remitted the accessory penalties that attached to the principal penalty of reclusion perpetua. Okay, so that's the decision of the Supreme Court. If you will be asked in the bar examinations the distinctions between amnesty and pardon, I have here a table prepared for you so that you can easily answer either the objective question on the distinctions of amnesty and pardon, or a problem involving the application of amnesty and pardon. So what is the first distinction is in amnesty, that is a public act which the courts can take judicial notice. The pardon is a private act. The effect is the court cannot take judicial notice of it. It must be alleged and proven during trial. The second distinction is the amnesty is granted generally before or after the execution of the criminal prosecution, sometimes even after conviction. While pardon is granted to one after conviction only. And the third, amnesty looks forward and abolishes and puts into oblivion the offense itself. And pardon, on the other hand, looks forward and relieves the offender from the consequences of an offense which he has been convicted. Okay, that's the distinctions between the two. Now we go to the more controversial ground, which is prescription of crime. This is timely, since lately the Rappler editor-in-chief, Ms. Maria Riza, was convicted with online libel, and the defense of prescription was set aside by the trial court. So what is prescription of crime? Prescription of crime is the forfeiture or loss of the right of the state to prosecute the offender due to lapse of certain period of time that is fixed by law. So forfeiture meaning the loss of the government or the state. So the state did not prosecute, did not initiate to file a case against the criminal offender. It sleeps on its right. It is now stoop, or the principle of estoppel in laches, right? Can be used against the state. So the state is given a certain period of time within which to initiate and prosecute the criminal prosecution. But upon the lapse of that time, the right of the state is extinct. To prosecute is extinguished. That's the main reason. Okay, so despite the fact that the state is given a period of time to prosecute, it failed to do so. So that is waived. Waived na, forfeit na. Okay. So what is the governing law insofar as prescription of crimes? That is under Article 90 and 91 of the Revised Penal Code. We have here the number of years or the period that a certain crime would prescribe, and it is dependent on the gravity of the penalty. So if the crime is punishable by reclusion perpetua and reclusion temporal, 20 years. If it is punishable by prison mayor, 15 years. If it is punishable by correctional penalty, it is prison correctional, or dischero, 10 years. Arresto mayor, 5 years. Libel or similar offenses, 1 year. Oral defamation, 6 months. Oral defamation, simple, 2 months. And light offenses, excuse me. What about offenses or those crimes punishable by special penal laws? We have a special law, Act number 3326, that governs the prescription. So, if, for example, a crime is for violation of the drugs, comprehensive drugs law, RA 9165. Also, the governing law, and so far as prescription is concerned, is Act 3326. If it is punishable by fine or imprisonment, but not more than 1 month, 1 year. Imprisonment of more than 1 month, but less than 2 years, 4 years. Imprisonment for 2 years, but less than 6 years, 8 years. Imprisonment for 6 years or more, 12 years. And violation of the National Internal Revenue Code, 5 years. And violation of municipal or city ordinances, 2 months. Take note of that, please. Because later on, we will go back to municipal ordinances. Now, this is the table for the basis, okay? The distinction between the prescription for felonies or for violation of the revised penal code and the special penal laws. When prescription starts to run, if it is a felony or violation of the revised penal code, it starts to run from the discovery of the crime. And if it is a violation of a special penal law, it starts to run from the commission of the crime. If known, if not, from the discovery. And when it is interrupted upon the filing of the complaint with the prosecutor's office. SPL, same. What about if the accused or the offender is absent from the Philippines, is abroad? If it is a violation of the revised penal code, it will not run. So the prescriptive period is told. Okay? But if it is a violation of a special penal law, it runs even if the accused is absent from the Philippines. Take note of that. That is a very important concept. Okay. What are the rules to be observed in applying prescription? The period of prescription for the offense charged should be taken into consideration. The time the period of prescription starts to run and the time the preventive prescriptive period was interrupted. This must be taken into account. Okay? So I'm just laying the rules for you to observe. And in computing the period, the first day is to be excluded and the last day included. So if the prescriptive period is 2 months, you have to started counting the prescriptive period tomorrow. Okay, because the first day is excluded, so the start of the counting will be tomorrow. Okay, so that's the rules. And the last day is to be included. And what about if the last day is a Sunday or a legal holiday? O katulad ngayon, it's like we have an extended holiday because of some calamities or due to force majeure or fortuitous event. The last day expired or falls on the on holiday or Sunday. the rule is it cannot be extended. So if the last day is Sunday or Monday, you can no longer file a case against the accused because that is automatic, ipso facto. You cannot extend it. That cannot be extended. Okay, so that the application of criminal law is strict if it is will be against the accused. So the law should be construed strictly against the government, against the state, and favorably and for the accused. Okay, so that's the rule. And sabi ko na nga, the last day, the loss, the prescription or the loss of the right to prosecute is automatic and by operation of the law. Okay. So the running of the prescriptive period starts from, just like here, from the discovery of the crime. Okay, from the discovery of the crime. So for purposes of knowing the prescriptive period, when to start the prescriptive period, the crime must be discovered by the what? By the offended party or the authorities or their agents. So, yun po. The discovery must be made by the offended party or by the authorities, by the police authorities or their agents. Okay? However, Article 91 does not mention who is the offended party. So, who will be considered the offended party? Okay? So, jurisprudence tells us that the offended party should be understood to mean the offended party that is provided for Rule 110 of the Rules of Court or Criminal Procedure, which defines the offended party as the person against whom or against whose property the offense was committed. So that is the definition of the offended party for purposes of prescription. We borrow the definition provided for under Rule 110 of the revised Rules of Court. Okay. So the offended party here is the party to whom the offender is civilly liable. So if a husband is killed by the accused, who is the offended party there? The offended party is the wife or the children, the legal heirs of the deceased. So that's the meaning of the offended party for purposes of prescription. In the crime of bigamy, while it is a public crime, it is entirely incorrect to say that it is the state that is the offended party. Who is the offended party in the crime of bigamy? The Supreme Court said that it can either be the first or the second spouse. You know, the crime of bigamy is committed if the offender contracts subsequent marriage, where the first marriage is still subsisting and he contracts another marriage. That is bigamy. So it involves 2 or 3 marriages. And who is the offended party there? According to the Supreme Court, the offended party is either the spouse, the first spouse, or the second spouse. Okay, so the second spouse can be considered as an offended party because maybe he or he does not know the fact that the person he or she contracts marriage with was previously married. So it can be the first or second spouse who is the offended party. So the counting of prescription in the crime of bigamy starts to run from the discovery of the crime by the offended party, when that is the first or the second spouse. Take note of that. That is a very important concept. What about crime of falsification of public document? Now, we have here the so-called constructive notice rule. What is this rule all about? Constructive notice rule pertains to the registration of a certain document with a government office. Okay, so the office could be an exchange commission, insofar as corporate papers are concerned, just like secretarial certificate, um, the articles of incorporation, and so on and so forth. Or it could be a register of deeds or land registration authority, insofar as titles of land are concerned. So the registration of those documents is the reckoning point of the counting of prescription. Okay, so that's the rule. In case a secretarial certificate is registered with the SEC, Securities and Exchange Commission, the prescriptive period will run from the registration of that document. If that document, assuming it is falsified, is not registered, so there will be no running of the prescriptive period. Okay, that's the constructive notice rule. In other words, the prescriptive period will start to run from the date of registration. But in the crime of bigamy, again, the constructive notice rule is not applicable. So if the second or subsequent marriage is registered with the civil registrar, local civil registrar, or PSA, Philippine Statistics Authority, the registration of it is not the starting point. What is the starting point in the crime of bigamy? The starting point is the date of the discovery by the offended spouse. Okay, what's the reason behind? According to the Supreme Court, it is unfair to the offended party to that the constructive notice should apply to him or to her, since bigamy or subsequent marriage is done in utmost secrecy. As much as possible, it must be secret. It should not be known to the whole world. It should not be broadcasted to the whole world that the offender had incurred or contracted subsequent marriage. As much as possible, it should be secret. It should remain secret. So why apply the constructive notice rule? So Supreme Court protected or protects the offended party. So in bigamy, the constructive notice rule does not apply. Okay, so the starting point in counting the prescriptive period in the crime of bigamy is from the date of discovery. Okay, so this is important. The interruption of the period of prescription period. When is the prescriptive period interrupted? The general rule is, under Article 91, the filing of the complaint or information interrupts the running. It does not distinguish whether the complaint is filed for preliminary examination or investigation only. Okay, so if a complaint is filed with the prosecutor's office, that is automatic. By operation of law, it is interrupted. Even if the prosecutor office takes 1 year or 2 years to decide to resolve the complaint, it is interrupted. Okay, so there will be no running of period while during the pendency of the case filed with the prosecutor's office. It is not only prosecutor's office. In one case decided by the Supreme Court, the investigation conducted by Securities and Exchange Commission or SEC for violation of Securities Regulations Code, even if it is not preliminary investigation, the running of a prescriptive period is suspended or interrupted. Okay, so that's a decided case. Okay, so if there is an investigation not conducted by the prosecutor's office, or in case of SEC, that is interrupted. Okay, is it applied only to felonies or special penal laws? Both. There's a uniform rule now, procedure now, that even if it is for violation of special penal law, just like BP 22 or the anti-bouncing check law, this filing of the complaint with the prosecutor's office is a ground for suspension of prescriptive period. Okay. Okay. That has been settled in the case of Panagiton versus the OJ et al. Okay. Whether it is a violation of revised penal code or special penal law, you have to suspend the running of the period. Okay. So, however, there is one case, Aldivia versus Reyes, and J. Duell parking case decided or penned by Justice Marvick Leonen just recently, 2 or 3 years ago, that with respect to violation of municipal ordinances, a while ago I flashed the table for the prescriptive period of municipal ordinances, which is 2 months. If the case is for violation of municipal or city ordinances, the filing of the complaint with the prosecutor's office does not suspend the running of the period. So take note of that. The jurisprudence is now settled that if the case is all about violation of municipal ordinances, the running of prescriptive period is not told when the complaint is filed with the prosecutor's office. Why? Is it not the fact that municipal ordinances, the prescriptive for municipal ordinances is also provided by Act number 3326? Why not apply the same rule in Panagiton versus DOJ? Supreme Court cited that it is the applicable law is the rules on summary procedure under BP or Batas Pambansa Bilang 129, which provides that the prescriptive period will only be suspended or told if information is filed with the trial court. Okay, so under section 9 of the rules on summary procedure, that is a substantive law because that is under BP 129, Batas Pambansa Bilang 129, that the prosecution of criminal cases falling within the scope of these rules on summary procedure shall be either by complaint or information to be filed directly in the court without the need of a prior preliminary investigation or preliminary investigation. What about the rule that there is no prescribing the direct filing of complaint or information with the, especially in Metro Manila or other chartered cities? There's a rule that you cannot file the complaint or information directly with the trial. It must pass through the office of the city prosecutor. Problem. So, what if the city prosecutor's office takes 3 months to decide or to resolve the case? Is it not unfair to the private complainant that the case will be dismissed or will prescribe due to some negligence of prosecutor's office. Well, that is the law. We have to apply this law between substantive law BP 129 and rules on and Rule 1110 of the Rules of Court, Criminal Procedure. The substantive law shall be preferred, or shall prevail over the procedural law, okay, which is Rule 110 of the Rules of Criminal Procedure. So if it is a violation of municipal ordinances, there is no suspension of the prescriptive period. I hope that is clear, right? So I've told you the existing jurisprudence. Okay. Take note that in cases cognizable by the Katarungang Pambarangay also, if the penalty is not more than 1 year under the local government code, all disputes must be brought to ilupon tagapamayapa of certain barangay. If the residents or the litigants are residents of the same barangay, it must be brought to the lupon tagapamayapa. What is the effect of the filing of the complaint with the lupon tagapamayapa? Well, by express provision of the law, the same shall be suspended. And it will continue to run after the termination of the proceedings in the lupon tagapamayapa. So, if the complainant has 30 days more after the termination of the proceedings in the lupon, and he does not file the case, despite the issuance of a certificate of file action, then the action will be considered prescribed. Okay, so that's the rules on prescription on involving municipal ordinances. What about absence of the accused from the Philippines? Earlier in my table, I said that in case of violation of the revised penal code, or if it is a felony, and the accused is abroad, the prescription of crime will not run. But if it is a violation of a special penal law, just like Anti-Graft and Corrupt Practices Act, and the accused or the offender is abroad, beyond the reach of Philippine laws, according to the Supreme Court, in case of Benjamin Romualdez versus People versus Andean Bayan, the court was divided in this case. According to the majority opinion, the absence of the accused from the Philippines will not be a ground for the suspension of the running, meaning it will continue to run. So if the accused is abroad and he stays there for quite some time, and he returns to the Philippines upon the expiration of the period, then he will not be he cannot be charged anymore because of prescription. But the rule does not apply if it is a felony or a violation of the revised penal code. So those are important aspects that you should learn or you should be aware of. And if it is a continuing crime, just like rebellion, that does not prescribe. The action does not prescribe, because in continuing crime, every day, the same is committed. Every day, there is a continuing commission of the crime. Okay? Or for violation of Republic Act 9262, or the violence against women and children, if it is economic abuse, the failure of the husband to support his dependent, every day that he fails to support is a continuing crime. So it never prescribes. It does not prescribe. Take note of that. What about this case of Maria Risa case? This is controversial. This prescription of cyber libel. You know, the background of this case, Maria Risa was charged with cyber libel before the Regional Trial Court of Manila. And after the prosecution has rested, Maria Risa did not adduce evidence because her defense is prescription. So Maria Risa was confident that the court will appreciate prescription because if the action prescribes, that is automatic and raise it anytime at any stage of the proceedings. But the trial court here did not side with Maria Risa. It convicted her with cyber libel, saying that the action has not yet prescribed. Because you know, libel under Article 91 or 90 is prescribes in 1 year. According to the Supreme Court, that is not applicable because under Republic Act 10175 or the Cybercrime Prevention Act, the prescriptive period will be 15 years. Why? Because the cyber libel is punishable by the traditional form of libel under 355 of the revised penal code is punishable by question correctional. 1 year lang. No, yes, 1 year. But after applying RA 10175, cyber libel, according to the trial court, that is a qualifying circumstance that increases the penalty 1 degree higher. So the maximum of the penalty for cyber libel is now within the coverage of pression mayor. That makes it an afflictive penalty. Under Article 1991, afflictive penalty, just like pression mayor, prescribes in 15 years. So that's the issue now. Is the trial court correct? I have my opinion here. I have stated my opinion whether the trial court is correct. Okay. Let's first analyze what is cyber libel. Cyber libel is a crime punishable under Republic Act 10175. Okay? We have traditional form of libel punishable by the revised penal code under Article 353, 354, 355. The penalty of cyber libel under RPC is much lower, not pression mayor. Okay? But according to RA 10175, if there is in the commission of the crime, it involves the use of computer or internet. It is a qualifying circumstances. What is the meaning of that? It increases the penalty to 1 degree. That's the effect of Republic Act 10175. Question: is there a separate crime of cyber libel, or is cyber libel different from libel under the revised penal code? Or is cyber libel is cyber libel a qualifying circumstances only of libel under Republic Act, under revised penal code? Okay, let's analyze one case decided by the Supreme Court, the landmark case of Dicini versus Secretary of Justice. According to the Supreme Court through Justice Abad, cyber libel is not a new crime. Okay, because cyber libel, this is the decision of the Supreme Court. Cyber libel is actually not a new crime, since Article 353 and 355 of the revised penal code already punishes it. In effect, cyber libel merely affirms that online defamation constitutes similar means for committing libel. Okay, so libel under the revised penal code and cyber libel are not different crimes. I agree to this because in cyber libel there is no separate penalty. Penalty is to be borrowed from the revised penal code. If there is cyber libel, the penalty will only increase 1 degree higher. Oh. Republic Act 10175 does not provide for a penalty of its own. It borrows the penalty of the revised penal. So libel under RPC and cyber libel under RA 10175 are one and the same. The only distinction is in cyber libel there is a use of computer system. Okay? So pagkapareha sila, they are the same because the elements of cyber libel are the same with elements of the form. So what is now the prescription of cyber libel? That's the provision of the revised penal code, particularly Article 19, cyber libel. Just recently, the Supreme Court in People versus Tolentino, in a minute resolution, said that cyber libel prescriptive period is what? 15 years. Tolentino versus People. This is a 2019 decision of the Supreme Court, but it is just a minute resolution. According to the Supreme Court, it is what? It prescribes in 15 years because it is maximum penalty is prescription mayors in its minimum period here. But I have reservation insofar as Tolentino versus People is concerned. Why? It is just a minute resolution. According to the same Supreme Court, according to the Supreme Court, a minute resolution has no binding effect insofar as other parties are. The res judicata rule will only apply to the same parties. In that case, the effect of that decision will only bind Tolentino and the complainant. So it will not bind other cases because it does not apply. It is the binding effect of it does not apply to other persons. That is a jurisprudence. Okay, so since it is just a minute resolution, it only applies to Tolentino. It will not apply to other cases, just like Maria, Risa. So my opinion, I agree with the observation of the Supreme Court in the Decini case that libel, cyber libel, is not a new crime in our jurisprudence. So, since libel and cyber libel are one, the applicable provision here is Article 91 of the revised penal code, where the prescriptive penalty for libel is just 1 year. Okay, this one. Okay, so since libel has a separate prescriptive period, that is 1 year, under Article 90 and 91 of the revised penal code, it is the prescriptive period is only 1 year. Take note that the law uses similar offenses, libel and similar offenses, borrowing the decision, the wording of the Supreme Court in Decini versus Secretary of Justice, that cyber libel is a similar offense, like of libel. Then it is considered falling under this phrase, similar offenses, that may be that may include cyber libel. So the prescriptive period of cyber libel is only 1 year. That is my opinion. That is only my opinion. Okay, so because there's no Supreme Court decision yet on the matter. I will not. I have reservations insofar as Tolentino versus People is concerned because it is just a minute resolution. I'm not saying that is not a valid resolution, because minute resolution is also valid. But borrowing again the jurisprudence of the other decisions decided by the Supreme Court, that prescription, that minute resolution is only binding upon the parties, not with respect to other person. Okay, that is my opinion. Okay, prescription of penalty, it is just like prescription of crime. It is a forfeiture or loss of the state to prosecute cases after a lapse of time, because the convicted person has not yet been arrested. Okay, after his conviction, he is at large. Okay, so what is the prescriptive period? If it is punishable by reclusion perpetua, 20 years. Afflictive penalties, just like prison mayor, 15 years. Correctional penalties, prison correctional, 10 years. And arresto mayor, 5 years. And life penalties, 1 year. What are the rules to be observed? The prescription of penalty will start to run from the date when the convict evaded the service of sentence. When you say evaded, he has already been convicted, and he will be brought to the National Penitentiary for to serve his sentence. Or if he's already brought to the National Penitentiary, just like in Muntinlupa, he escaped from prison. So that's the time that the prescription of penalty starts to run. And it is interrupted if the convict surrenders or arrested, or he goes to another country, which the Philippines has no extradition treaty, or if he commits another crime before the expiration of the prescriptive period. Okay, so those are the interruption, the grounds for interruption of the interrupting the counting of the prescriptive period. Okay. So the concept of evasion of service of sentence is the same in the crime of evasion of service of sentence under Article 157. There is a crime of evasion of service of sentence if the accused escapes, escapes from prison. Okay, that's the same concept applicable in the prescription penalty. So, if the offender has not yet been arrested and is not serving his sentence, is at large, there can be no prescription penalty. Prescription and penalty does not run in his favor. It's like when he is convicted in absentia. During the promulgation of sentence, he was not present. He was at large. He did not surrender. So the prescription of penalty will not run insofar as he is concerned. What about marriage and pardon? Okay, the pardon here, just like I've mentioned earlier, refers to the act of the private complainant. In cases or in crimes against chastity, it's like rape, seduction, abduction, or acts of lasciviousness. Okay, so pardon given by the offended party extinguishes the criminal liability, provided, however, that the pardon must be given before the institution of the case. That is, before the filing of the complaint, even before the prosecutor's office. And pardon given after the institution of case or criminal case is no longer valid. Okay, pardon can be expressed or implied. Expressed if it is when the offended party or the victim executed an affidavit of resistance. Or implied when he's no longer he did not or she does not file a case against him, against the offender. Okay, and in pardon involving the crime of concubinage or adultery, there is an implied pardon or condonation when the offended party, just like if it is a wife who is the offended party, if the wife continues to live with her husband, even if she already knew about the act, the crime committed by her husband, which is concubinage, if she continues to live with him, that is an implied condemnation. So, ibig sabihin, the wife has forgiven the accused, okay? Or they are still intimate, despite the knowledge of the wife about the activities of her husband. She continues to have sexual intercourse with him. That is an implied pardon or implied condemnation. But however, that is subject to the condition that the wife knows the crime committed by the husband. If the wife does not know or has no knowledge about the crime committed by her husband, that is not an implied condemnation or implied pardon. Same with husband. If the husband continues to live with his wife despite the knowledge that the wife committed adultery or adulterous act, that is implied condemnation. So that will extinguish the criminal liability of the wife. Okay, so that's pardon. What about marriage? Marriage is only applicable for the crimes of seduction, abduction, acts of lasciviousness, and rape. It is not a ground for extinguishing criminal liability for the crime of adultery and concubinage. That is understandable because in the crimes of concubinage and adultery, the accused involved is already married. So the offended party cannot extend or cannot marry one of them because kasal na sila. Okay? So in adultery and concubinage, one of the elements there is the offended party or the offender is married. So he can no longer contract, she can no longer or he can no longer contract another. So marriage is only with respect to the crimes of seduction, abduction, acts of lasciviousness, or rape. And the condition is the marriage must be made in good faith. If it is made out of because of convenience or for reason of convenience, the accused would only marry the victim because he does not want to be imprisoned. So that is not in good faith. So the marriage here, in order to validly extinguish criminal liability, must be done in good faith and as an expression of love, expression of their mutual love for each other, and the desire to establish a family of their own. And the effect of marriage, if there are two accused or three accused, one of the accused marries the victim, the other co-accused will also enjoy the benefit of it. Okay, so that's these are the distinction or the marriage or pardon will extinguish criminal liability in crimes of seduction, abduction, acts of lasciviousness, and rape, while pardon will only extinguish adultery and with respect to partial extinction of criminal liability, we have commutation of sentence, conditional of pardon, good conduct for time allowance, and special allowance for loyalty. Okay, we'll start with commutation of sentence. This is a very easy concept. Commutation of sentence is nothing more than a reduction of the penalty or of the sentence imposed by the court. Who will undertake this? This an executive clemency, the president or the chief executive of the Republic of the Philippines. He reduces the sentence or the penalty that was imposed by the court. So it involves a decrease on the length of imprisonment or fine. So pardon and commutation. Pardon involves remission. Commutation is reduction. Okay, so that's a different concept. Pardon is remission. The, the criminal liability is extinguished totally or partially, or by virtue of absolute or conditional pardon. While commutation is just a reduction of the penalty. So that is the distinction between the two. What about good conduct allowance? You know, recently, last year, there was a news about former Mayor Antonio Sanchez, the convicted prisoner who raped and killed Eileen Sarmienta many years ago when I was still a new lawyer then. According to the news, Mayor Sanchez was about to be released because he already earned the so-called good conduct allowance. And recently, in the case of Pemberton, the killer of Jennifer Laude, also reportedly he was a beneficiary of good conduct allowance. Okay. What is this? Good conduct time allowance reduces the actual time a prisoner will serve his sentence, because it arises from having observed prison rules and regulations, and it will automatically accrue whenever a person has shown exemplified good behavior, or he spends time for studying or teaching or mentoring other prisoners. This is given by the law, revised penal code. Who are entitled to this? First is, if you are serving sentence, you're sentenced by final judgment, meaning to say, you're a convicted felon. The court has convicted you. You are entitled to this. And under the new law, Republic Act 10592, even prisoners serving preventive imprisonment, meaning those prisoners whose cases are still pending for trial. If you are detained at the city or municipal or provincial jail, and the case is still pending, if you have spent, assuming 6 years or 5 years inside city jail, if you cannot afford post bail, or if your case is non-bailable, and if you are convicted subsequently, assuming 8 years, if you are convicted to suffer a sentence or imprisonment of 8 years, and you have spent serving or the so-called preventive imprisonment for 4 years, 4 years will be deducted from 8 years, meaning to say you will only suffer to serve the sentence for 4 more years, because the 4 years that you have stayed inside the city jail will be counted or credited to your sentence. So that is preventive imprisonment. So if you're just under preventive imprisonment, you will earn good conduct allowance. Yeah, that's the meaning of it. Okay. So who grants the allowance? If you are a convicted prisoner, director of the Bureau of Correction. If you're just a detention prisoner, the jail management, the chief of the Bureau of Jail Management and Penology, or the warden, the head of the city jail or provincial jail, the warden. And who are not qualified. If you are a recidivist, if you've been convicted twice for crimes under the same title of the revised penal code, you are a recidivist. Or if you are a habitual delinquent, if you are convicted for 3 times already for crimes enumerated under the concept of habitual delinquency, you are not qualified. And if you are an escapee, if you escape from prison, you are not entitled. And if you are charged with heinous crime, oh, heinous crime, there are so many kinds of heinous crime: rape, kidnapping. So, mere charge of heinous crime is you are not entitled to it. And these are the period to be deducted. Okay, not important for us, for law students or lawyers. This is the concern of the Bureau of Corrections, Bureau of Jail Management, Penology, or Warden. The court does not grant allowance. It is only the concern of the prison officials. That's why every prisoner inside city, municipal, or provincial jail or national penitentiary has a separate book or record. Every infraction of prison rules is being recorded there. Or every activity that is considered within the concept of good conduct is also recorded there in your book. So if you have violation, you will not get an allowance. If you have exhibited good conduct, this is your allowance. Okay? First 2 years, 20 days off. Oh, malaking bagay. It is a very substantive or substantial reduction. Even if the case is on appeal, the computation of good conduct allowance continues. So here, you have to be knowledgeable of what is good conduct, because this is a new case. In a 2019 case decided by the Supreme Court through Justice Peralta, the case of inmates of Bilibid Prison versus Secretary de Lima et al. The Supreme Court enumerated the so-called good conduct. These are the concepts underlying the concept of good conduct. So one is one who has not been guilty of violation or discipline or prison rules. You have not violated any rules and regulation of the national penitentiary or city jail or municipal jail. Number two, one who displays good behavior and no record of breach of discipline or violation of prison rules and regulations, just like the first. Third, conspicuous and satisfactory behavior of a detention or convicted prisoner when he is involved in rehabilitation programs, productive participation in authorized work activities or accomplishment of exemplary deeds. Or when you obtain diploma or certificate because you engage in some educational program or course, you are entitled to good conduct allowance. Once granted, the allowance shall not be revoked. Okay? So there must be a faithful compliance of these rules. Otherwise, there is a corresponding criminal liability. Okay? So if you have gained or obtained good conduct allowance, there will be reduction from your sentence. A special time allowance for loyalty that is given when there is what? Calamity, just like what happened a couple of weeks ago. When there is catastrophic calamity, mutiny. And the prison facilities, for example, were destroyed or binaha. There was flooding, assuming. And the prison facilities were damaged, destroyed. If you leave the premises, you will not incur criminal liability or administrative liability, provided that you should return within 48 hours following the proclamation by the President of the passing away of such calamity. You are enjoined to return to prison facilities within 48 hours. If you return, you're entitled to 1/5 deduction of your sentence. Oh, that is very helpful. Helpful, yeah. You will be entitled to 1/5 deduction of your original sentence. What about if you stay, you did not leave the premises? You will be entitled to not to 1/5 but 2/5 of your original sentence. Okay, because of loyalty, you're loyal by returning to the prison facilities or by not leaving the prison facilities. You will be entitled to this. Why is it that the one who leaves the premises is entitled? Because according to the Supreme Court, the government will be spared from expenses. Okay? Because the government resources will be used for the rehabilitation of the prison facilities. And during the rehabilitation, the government will be spared, will save its funds from maintaining the prisons, from providing food and other maintenance expenses for the prisoners. In the meantime, that the rehabilitation is being undertaken. So if you return, you will not be charged with evasion of service of sentence, provided that it must be within 48 hours. Okay, so that's special time allowance for loyalty. Now, we are now the last two concepts of our lecture. We'll just discuss indeterminate sentence law and probation, after which this lecture is over. Okay, so indeterminate sentence law, many law students and bar examinees are allergic to this law because according to them, they are being required to compute the sentence because law students are afraid of mathematics. Okay? But this is a very simple law. Indeterminate sentence law. What is indeterminate sentence? Asked that this was asked last two bar examinations, I think. Okay, it is a sentence with minimum and maximum term. So from that phrase, it is a sentence with minimum and a maximum term that is imposed upon a convicted person who is not disqualified. And the minimum and the maximum penalty of imprisonment must exceed 1 year. Because if it is less than 1 year, you are not qualified to this indeterminate sentence. Okay? If you are the maximum term is not to exceed 1 year, you are not entitled. That's the first exception. So, when is the criminal liability, the extinction of criminal liability, when does it come into the picture? Kailan? The criminal liability will come into picture, the extinction of criminal liability will come into the picture when the convicted prisoner has reached the minimum term. If he has served the minimum term of the indeterminate sentence law as computed by the court, by the trial court. What is the effect? Because if you have reached the minimum term of the indeterminate sentence, you are now entitled to parole. Parole, meaning to say, the Board of Pardon and Parole will facilitate your release from prison. You will be released from prison because you have already reached the minimum term. What is the concept? What is the rationale behind? Because the law is interested that you can still be productive in your remaining years of your life. Do not complete the maximum term. Just complete the minimum term according to the law. And I will release you so that you can still be productive. You can still be a productive member of society. So that is the rationale behind why the law allows you to be released from prison. So that is where the extinction of criminal liability lies. Take note of that. So that is parole. Okay? Parole. So, so if you will be asked, can the court impose a penalty involving straight imprisonment? Assuming the law, the court imposes 3 years straight imprisonment. Oh, that was asked last year. Last year or rather year. What is the answer? The court imposes a penalty 3 years straight penalty imprisonment. Is that valid? The answer is no. Why? That is in violation of the indeterminate sentence law, because the law requires the court to compute the minimum and the maximum term of the sentence to give way to the application of parole, so that parole can be extended to the convicted upon serving the minimum term. Okay, so that's the rationale. That's the rule. Rationale why indeterminate law is required. It is compulsory or mandatory, unless it is one of the exceptions, and the exceptions are here. The first exception is if the convicted prisoner is penalized with the penalty of death or life imprisonment or reclusion perpetua in lieu of the death penalty. If the penalty is reclusion perpetua, disqualified. If the penalty is life imprisonment for violation of a special penal law, just like selling of shabu under Republic Acts 9165, that is punishable by life imprisonment, you are not qualified. Okay. Number 2, those convicted of treason, conspiracy, and proposal to commit treason, misprision of treason, rebellion, sedition, espionage, or piracy. Okay, so those specified crimes, you are not entitled. Or you are habitually delinquent. What is habitual delinquency? Habitual delinquency is when there is 3 convictions. There are 3 convictions, I'm sorry, within the period of 10 years from the date of release or conviction. You are convicted for the crime of what? Falsification, robbery, theft, tapa, serious physical injuries or less serious physical injuries. You are a habitual delinquent. You are not entitled to parole. But recidivists are entitled to parole. What is recidivist? One who is convicted twice for crimes embraced in the same title of the revised penal code. That's the distinction between habitual delinquency and recidivism. Next exception those who have escaped from confinement or evaded sentence. For those who have been granted conditional pardon and violated the terms thereof. Or the last exception is when the maximum period of imprisonment does not exceed 1 year. So how to compute? You have to compute first the maximum term. The maximum term corresponds to that which, and applying the attending circumstances, the modified circumstances. You have to lower it if there is 1 or 2 or more mitigating. You have to increase it if there is aggravating circumstance. Okay? And the minimum term is the 1 degree lower. If the maximum is reclusion temporal, that is the maximum, the minimum term will be presión mayor. That is within the range of 6 years and 1 day. How to fix the minimum? Discretionary upon the court. So the minimum will be 6 years and 1 day. The court may impose 7, 8 years or 9 years, depending upon the discretion of the court. So this is the procedure how to determine the maximum term. Okay, you have to apply. You have to know the provisions of Article 64 of the Revised Penal Code. That is application of penalties containing divisible or 3 periods. Okay. If no aggravating, no mitigating, medium, there is aggravating, no mitigating, maximum. There is mitigating and no aggravating, minimum. If there are more, 2 or more mitigating, 2 or more aggravating, you apply the offsetting. Whatever remains, if it is mitigating, you reduce. If it is aggravating, you increase to maximum. So that is Article 64. And to know the duration of this penalty, if it is maximum, minimum, or medium, you have to refer to Article 76 of the Revised Penal Code. That is where you can find the range of penalties. Okay. So the minimum, in determining the minimum, the court has the discretion. You apply this. The court will apply this criterion or this criteria. Okay. So what are the criteria in applying the minimum? Well, the court can appreciate whether the criminal is what is or these are the factors to be considered: his age, his general health, his mentality, his previous conduct, etc., etc., etc. These are the factors to be considered. Whether to reduce the penalty up to what particular year. So these are the factors to help the court in determining the minimum term. Okay, the first aspect and the second aspect, and of course the factors. These are the factors to be considered. Okay, so parole is there. I've already explained that parole is given after the prisoner has reached serving the minimum term. Okay, that is not automatic. The Board of Pardon and Parole will evaluate, will assess. And if you are qualified, then you are released from prison. Okay, so just like conditional pardon, if you violate some of the rules or terms, then you can be recommitted, you can be rearrested and recommitted to prison. So the grant of parole is not automatic. That still needs to be verified, needs to be evaluated, needs to be assessed by the Board of Pardon under the Department of Justice. Okay. So these are the distinctions between conditional pardon and parole. In conditional pardon, it is given by the President. Parole is given by the Board of Pardon and Parole. Okay. For violation of conditional pardon, the offender may be rearrested or may be charged for violation of Article 159, evasion of service of sentence. On the part of a parolee, his violation will he will be rearrested and to serve the unexpired portion of the penalty. And last is probation. This will be my last topic. We'll have after this, my lecture is over. Probation is a disposition under which the prisoner or the accused will not be imprisoned. He will be released, subject to the conditions imposed by the court and to the supervision of the probation officer. The indeterminate sentence law, the concern of the court is just to compute the minimum and maximum. And it is now the turn of the Bureau of Parole and Pardon to determine whether the accused or the offender is qualified after serving the minimum. Here, in probation, it is the concern of the court not to order the detention of the accused. He will not be in prison. He will not stay inside the prison facilities just even for a minute. He will remain as free as a bird. Okay, so probation is not a cause for incarceration. He will remain outside in the outside world. Okay, but the court must evaluate whether he is entitled to it. First is what? If it does not fall under one of the exceptions. The first exception is when the maximum term of imprisonment is more than 6 years. Okay, so the imposable penalty is not more than 6 years. Pag more than siya, no, you are not entitled. Okay, more than 6 years. Second is when he is convicted of any crime against national security. That is the Title 1 of the Book 2 of the Revised Penal Code. Treason, misprision of treason, conspiracy and proposal to commit treason, piracy, violation of neutrality, etc., espionage. Those are the crimes against national security. You are not entitled to parole. Probation. Number 3, if you are previously convicted by final judgment of more than 6 years, 6 months imprisonment and 1 day, you are not entitled to probation. Or those who have been once on probation, there will be no second nor third probation. If you have been on probation once, you are no longer entitled. Okay. Last bar examination. The question is, what about if the accused appeals the judgment of conviction? Is he entitled to probation? Ordinarily, if an accused files an appeal, there will be no probation. You have to choose whether probation, or appeal. You cannot have you cannot eat your cake and have it too. If you choose appeal, your probation is foreclosed. Or if you choose probation, you can no longer appeal. That's it. That's the rule. The case of People versus Francisco. However, as an exception to the rule, if the decision is appealed, originally the decision of the trial court, the accused is not entitled to appeal because it's more than 6 years imprisonment. If on appeal, the appellate court reduces the penalty to less than 6 years in such a manner that he can now is entitled to probation. In that case, even if the accused appeals the decision and the appellate court reduces the penalty to less than 6 years, the Supreme Court said you are still entitled to apply for probation. That is People versus Colinares. The 2011 Supreme Court decision, but asked for the first time in the bar exam last year, 2019 bar examination. Okay, so that is the only exception to that rule where if the accused appeals, no probation. Okay, so take note of that Colinares doctrine. So this is the Colinares doctrine. Okay, so that ends my lecture, and I hope I have conveyed some important concepts in criminal law one that you should focus on, especially in in in, in the modes of extinguishing criminal liability. So this is an updated lecture, and I hope you have gained something out of this lecture. Thank you very much for listening.